Okay, we are back, and we have our first guest today. We're honored to have Marin Cionca. Did I pronounce your last name well?
That's good enough.
Good
Was good
enough.
and
Good
oh, good
enough. Good
enough.
enough.
All right.
From the Cionca Law Group, and you do patent. I was confused by the phrase in here, so let's have you correct me here. Patent prosecution.
Yes.
So tell us what patent prosecution is.
Patent prosecution means guiding clients who invent something through the process of obtaining a U.S. patent, which is granted by USPTO, United States Patent and Trademark Office. So prosecution means I take the client from the time they believe they invented something. I do a patent search typically before we move forward to see if the invention is truly new and non-obvious. And then I write an application, I file it, I deal with the USPTO, with the examiners. If they issue a rejection, I respond to that, I argue with them to the end to make sure the client gets a patent in the end granted. That's
Okay.
patent prosecution, as opposed to patent litigation, where after you get the patent, you may have somebody who's infringing upon your patent, and then
Right.
you may want to sue him or try to negotiate a deal with him. So that's patent litigation. I'm doing the patent prosecution part, again, helping the clients obtain a patent.
Yeah, well, the value of having a patent and having the patent law firm behind you is quite evident. Many years ago, I had a client who invented the first cordless telephone, and he didn't make any money, inventing the telephone. He made all his money suing all the major Panasonics and whatever else. So, there's great value in having that patent law behind you. So tell us a little bit about how you work and what makes you a little different than most patent law firms.
One difference I would like to point to is the fee structure that I'm using, and that's a flat fee structure. I realized early on when I started my practice that small inventors and small businesses and startups typically are on a low budget, and they're very concerned about how much it is going to cost in the end to obtain a patent. So the budget it's a main concern they have. So my approach is to tell the client upfront what is going to cost for him to obtain a patent. So once I know what the invention is about, I have several levels of flat fees that I offer. So then I tell the client, okay, for your invention, for your particular invention, this is, let's say, medium complexity invention, I can offer you this fee level, which is this much. This is how much you're going to pay. And oftentimes, especially for what is called a non-provisional application, which is the larger application, which goes through the process to become a patent, I offer the option for the client to pay me half up front and half when I'm done with the work. Mm-hmm. So again, to make it more convenient.
But the key is people come to you, don't have any surprises. You tell them what it's going to cost, and it's a flat fee versus many law firms will charge an hourly rate, and you never know what you're going to get.
Exactly. That's the difference. There are no surprises in the end. The hourly fee-based system is just unpredictable, and small inventors and small businesses are not comfortable dealing with it and having a huge bill at the end.
Well, you mentioned that
yes.
something about, I think you said medium complexity. I mean, what does that mean? Why is something medium complexity as opposed to large or small? I mean, how does that work?
Yeah, that's very complicated, but I will try to simplify because I get this question a lot from my clients, and I think it's a very good question. Think about in the mechanical world, for example, right? If you just you came out with an invention that just improves a simple tool like a screwdriver, for example, right? Screwdriver is known, and it's been a tool that everybody's using, for decades or centuries. But now you improve the screwdriver. You came up with something that makes the screwdriver better. I don't know. You added some magnetic features to it, and you can secure better to your tool belt or whatever is going to be. This is a simple mechanical improvement, or maybe some electrical improvement to it. that will not take me long to write an application for. It's going to be a relatively simple invention, so the time I'm going to spend to describe this invention and then to claim it properly in the application is going to be smaller relative to other inventions. For example, I mentioned it earlier when we discussed a little bit before the show. Recently, I worked on an invention for a client in the computer world, in the app world. He designed an app that will help us all find our friends in very crowded or very large spaces. So you'll never lose your friends or family members when you go shopping, go to a concert, airport, whatever.
Or like at Mardi Gras. I can't tell you how many times I've lost people down in the French Quarter in Mardi Gras.
Here you go.
This has much use for me.
Okay, so a computer-based invention will typically be more complicated. That will be in what I call level 2, level 3. So I will look at that, and most of them will be in a mid-level or high-level of fee. So it's going to be that flat fee is going to be a little bit greater just because the invention is more complicated. I need to describe computer system, software system, flowcharts, processes, and so on. It just takes more time. Mm-hmm. But the client will know upfront what the fee is going to be.
You're listening to Close Up on San Diego Business here on KFSD AM 1450 and financialnewsandtalk.com. I'm your host, Barry Waxler, here with my co-hosts Andrea Kay and Al Arias, and our guest, Marin Cionca from the Cionca Law Group. So, Marin, tell us a little bit more about the type of products that you work on, that you'll work on for clients, because you can't service everybody.
Yes, I primarily focus on what I already mentioned, mechanical devices. I also have a few clients that are doctors, and I filed for and I obtained for them a few medical device patents as well. So mechanical devices, medical devices, and software-based invention seems to be a large chunk of what I'm doing. There is a lot of activity in this area right now, again, because the smartphones and people are developing apps every day that are doing different things. So.
The app world has to be crazy and really busy for you.
But even in the mechanical world, though, too, one of my favorite shows is Shark Tank. I just love watching all these people that have these ideas, and they're so creative, and a lot of them don't have patents, before they go before these people to ask for money. And I think, oh gosh, you're not patented yet. I have the perception that there's more entrepreneurs and more people innovating today than ever, or is it just that my perception because there is the TV show?
That's a very, very good question. I will say we are innovating at a higher speed. That will be my perception as well. Just dealing with my clients and being involved in this type of industry, I will say we are inventing and innovating at a higher speed, and I think that's a great thing that it's happening because that's how the economy grows, right? That's how businesses are starting. That's how people get employed. So yes, to answer your question, I think we are doing it at a higher rate of speed. Yes.
What is the speed of starting the process to getting the patent? What's the time frame on something like that? And I'm sure it depends on the complexity.
Yes, complexity. But
there's that word again.
There are two answers to this question. First, from the time that the client, let's say, seeks my advice and hires me, it takes me typically about 6 weeks to get an application filed. I need to work with the client, identify what the inventive aspects are. Then we nail them down. Then I write it, the disclosure requirements and so on, drawings and claims. And in about 6 weeks, I can file. That's the first response. After filing, we have two options. We can go through what is called the fast track option, which means within a year the client can get a patent.
Oh.
And I'm talking about utility patent, which typically takes longer and is the most important patent. But even that, we can get it within a year if the client opts for the fast track option, which means he needs to pay an additional fee to the USPTO, which for us what is now called
greasing a few palms. Is that what we're talking about, Marin?
I'm sorry, what was that?
Greasing a few palms.
It's a user fee. The IRS has them
Okay.
too.
Yeah.
I mean,
Hey,
it's
money
just,
talks, right, boys? You know what I'm talking
yeah.
about.
I mean, they will work. USPTO also see the government can work faster if you pay them more. Isn't that interesting?
Yeah. So
it's all about the Benjamin.
Everything is volume based here.
Yeah.
Yes.
So, well, tell our listeners a little bit about the type of challenges they might face when they have a product if they didn't get a patent, and what's the true value of having what you have patented?
Yes, that's a very good question as well. If you have a good product, see, and that's a question I get from my clients all the time. Look, okay, I invented this. Do I need to patent this? Look, my answer is this. Look, you don't have to patent to sell something. Oftentimes, there is some confusion the clients have thinking that I need to get a patent in order to be able to sell. It's like they believe it's a license to sell. No, that's not true. You can sell your product. But if you then obtain a patent, let's say a year or 2 years or 3 years down the road, your product is very successful in the marketplace. And you're going to have a lot of copies, a lot of competitors that will just copy your product and compete with you. Go to China and make it and sell it. You're going to want to stop them at that point. And the answer is always yes. Okay, if you're going to want to stop them, then you need to get a patent now. And there is time limits within which you can apply for a patent only. You cannot wait 3 years later and then, okay, I'm going to go to the USPTO to get a patent now. It's too late. So not having a patent, you expose your business at the risk of not having that monopoly for the next 20 years and allow everybody else to copy your product after your hard work of creating, thinking, inventing, developing, and launching the product.
Is it important to have the patent before you start sales? Is there any difference? Or as long as you get the patent before the competitors copy your product?
You have to have the patent before you sell, and you have only 1 year time frame to file. Let's say you launch your product today, you kept it confidential up to today, but now you're starting to sell. After you sell, you have maximum 1 year. And the law it changed a few years ago, and even that it's a very risky strategy. My advice to all my clients is the best thing you can do is file first before you talk to anybody with investors, developers, whatever. File first. Have an application on file, at least what is called a provisional, which is cheaper and faster. File something, have a record, then go talk to investor developers and thinking about launching.
That's great.
When do you have renewal rights for patents? For example, I'm thinking of the Coke bottle. And the Coke bottle's been around maybe 100 years. And it seems like it's exclusive. I mean, to a layperson like myself, it feels like the Coke bottle is exclusive. How did they manage that?
Do you mean the shape of the bottle?
Correct.
The shape of the bottle, it can be protected by a patent and very likely only a design patent. Because shape of something means it just changes the ornamental appearance of that, whatever it is, a bottle in this case. So that likely was protected by a design patent. And the design patent is only good for 14 years.
Oh.
So it's only good for 14 years. So after 14 years, the bottle, it cannot be protected unless it has some artistic features, which I don't recall to see anything on the Coca-Cola bottle. But if you have some artistic features that could potentially be protected by copyright. For example, the label that you see here on this bottle that we have on our table here, the label itself could potentially be copyrighted.
Yeah.
So because it has specific designs and logos and writing, the copyright is much longer. It's 70 years after life of the author, of the creator.
So you can see how it is complex.
Yeah.
It is complex.
So people need to get a hold of you and get the answers to these questions.
They do, which brings us to the point where we're starting to run out of time.
Yep.
Tell our listeners how they find you.
A good place to start is SanDiegoPatentLawFirm.com, SanDiegoPatentLawFirm.com, and from there they can find me and access even a fee schedule that I show for transparency to my clients.
What about a phone number? How can people find you by if they just want to call you and ask some questions?
They can call our toll-free number, which is 800-454-1360. Again, 800-454-1360.
Great. Well, Marin, I appreciate you being with us. It's been a great education in patent law. So
it's exciting to me.
Yeah, we look forward to talking to you some more.
I thank you for the opportunity.
Great. You're listening to Close Up on San Diego Business here on KFSD AM 1450 and financialnewsandtalk.com. I'm your host, Barry Waxler, here with my co-hosts, Andrea Kay and Al Arias, and we'll be right back after the break with our next guest, Jerry Vederick from Twin Anchors Boat and Yacht.